Either the Commerce Clause gives Congress a plenary power to regulate anything it pleases, or it doesn't, and let's have that argument.
Hi, I'm Nick Gillespie with Reason TV, and today we're talking with David Bernstein, the author most recently of Rehabilitating Lochner, Defending Individual Rights Against Progressive Reform. He's also a law professor at George Mason University. David, thanks for joining us.
Thanks for having me.
The Lochner decision, describe it briefly, and what is the controversy that surrounds this?
So New York State had a law that said that bakers were not allowed to work, even voluntarily, more than 60 hours per week. And the case eventually made it to the Supreme Court. A baker named Joseph Lochner challenged the law. And the Supreme Court, ultimately in a very controversial, close 5-4 decision, held that the law violated the right to liberty of contract, which the court said was implicit in the 14th Amendment's Due Process Clause.
So the court in Lochner, basically the court says, no, actually you can work as much as you want, as little as you want.
Or at least that you can't limit it to 60 hours.
Right.
And you can't single out bakers. They say, why bakers? There's no good reason to single out bakers. Bakers are adults. They have no particular disabilities. They're not living in some isolated company town that they can't escape from. They're just as capable as everybody else. If you're limiting just bakers, we think maybe there's some kind of reason behind it that is not really a health reason.
So, or it's like they're flying, obviously not in 1895, but they're flying airplanes, so they might be tired and there's a public health risk or something. Now, Lochner remains very controversial. In 2005, when Barack Obama was a senator, and California Supreme Court Justice Janice Rogers Brown was being considered for the U.S. Court of Appeals in the District of Columbia Circuit. He said about her, one of the things that is most troubling is Justice Brown's approval of the Lochner era of the Supreme Court. Keep in mind that same judicial philosophy was the underpinning of Dred Scott, the decision that said that black people have no rights, that whites need respect. Why is Lochner still inflaming passions? It seems like a pretty cut and dried thing. And why is it being compared with Dred Scott?
So Justice Oliver Wendell Holmes, who was the great progressive hero of the early 20th century on the Supreme Court, wrote a famous lone dissent in Lochner, where he talked about the right of the majority to enact their will into law, said there's no such thing as liberty of contract. Justice Holmes's dissent became a famous dissent that both liberals and conservatives use for their own purposes. So liberals use it to say that the Supreme Court should never get involved in economic matters at all, and leave that to democracy. Otherwise, corporate plutocracies will be able to work their will on poor workers. Conservatives use it to say that the Due Process Clause, which has also been used to protect all sorts of rights, including, very controversially, abortion, should not play any role in constitutional jurisprudence. Basically, it protects only procedure, no substantive rights. So both sides, just by happenstance, really decide to use Lochner ultimately as their symbolic case for everything that's wrong with the other side's jurisprudence.
So you're rehabilitating Lochner in your book, and how hard a job is that? I mean, is there a swelling movement to say, you know what, no, Lochner is right. There are rights, to contract, individual rights that cannot be legislated away, nor should be legislated away. Is that becoming more popular? And if so, how is it going to change the legal landscape in the future?
When you see really prominent, not just law professors, but even prominent politicians like Barack Obama comparing this relatively mild and not especially important in historical context Supreme Court opinion to Dred Scott, the infamous pro-slavery case, that's obviously pretty hard to overcome that strong a historical story that's been accepted about Lochner. But I think that conservatives and liberals each have some reason to reassess Lochner. Liberals, to the extent that they support unenumerated rights like abortion, they have, either you've made it up out of whole cloth, or there's at least a constitutional tradition saying that the state's so-called police power, regulatory power, does have some limits. On the other hand, conservatives are in this awkward position where they want to say, for example, Obamacare goes beyond Congress's commerce power, and they want to hark back to some of the precedents from the same time as Lochner. So on the one hand, they're arguing, yes, the Commerce Clause should be more limited as we held in the 1920s and 1910s. On the other hand, in cases like Lochner, the Supreme Court were a bunch of bozos who were just making stuff up. Well, if those bozos were making stuff up, maybe that means their Commerce Clause cases weren't so good either. So I think each side has some incentive to reassess what was going on. I think there is some reassessment on both sides going on.
You brought up the healthcare reform case that is clearly going to be going the individual mandate, the limits of the Congress's Commerce Clause powers. Do you have a sense of how Lochner will play out, or will that convince more justices to say the individual mandate is beyond the pale, or that it's totally within legislature's right?
Well, the ghost of Lochner clearly has sort of an anti-libertarian bias in the sense that if you think that Lochner was wrongly decided because either the court should interpret constitutional rights narrowly in general, or because you think, as the liberals argue, that the court should stay out of economic matters, that obviously creates a disincentive for judges to buck that. But I think by taking Lochner seriously as doctrine, maybe it was correctly decided, maybe it wasn't, but it wasn't this outrageous, crazy, evil opinion, we could then say, okay, so if Lochner wasn't that outrageous, then let's take the Commerce Clause case as it comes. It's not have nothing to do with Lochner. It's a different provision of the Constitution. Either the Commerce Clause gives Congress a plenary power to regulate anything it pleases, or it doesn't, and let's have that argument. I think it doesn't, but we can at least argue that without having to bring in this kind of irrelevant case from 105 years ago.
David Bernstein of George Mason University Law School, as well as the author most recently of Rehabilitating Lochner, which is available from the University of Chicago Press. Thanks for talking to Reason TV.
Thanks so much for having me.